Unit 21 North Carolina Key Point Review. Settlement involves the time when the buyers and sellers review and sign the necessary paperwork. Closing of the title take place afterward and involves, among other things, the transfer of title to the property from seller to buyer, the completion of a satisfactory title update, the closing attorney's receipt of authorization to disperse all necessary funds, and the recording the deed in the appropriate county registry. The buyer's due diligence process investigates the following, among others: title evidence, a current abstract of title with opinion of title from the buyer's attorney, or title commitment from the title insurance company; seller's deed, affidavit of title by the seller and documents showing the removal of prior encumbrances; soil suitability test, survey and the results of required inspections; leases, if tenants reside on the premises; successful final property inspection; settlement statement showing the amount and distribution of funds. To complete the transaction, the seller requires the following, among other things: payoff statement from the seller's lender noting the amount owed, evidence that the buyer has the necessary funds, settlement statement showing the distribution of funds. Depending on state law and local custom, settlement may be conducted by a licensed escrow company, in which case the parties may execute documents separately and never meet, or meeting of the parties at the escrow company, title company, lender's office, or attorney's office. An escrow or settlement agent is a disinterested third party authorized to coordinate the closing activities, usually an attorney in North Carolina. The Internal Revenue Service may require completion and submission of the Form 1099-S statement of income to the seller showing the seller's Social Security number. Form 1099-S is filed by a settlement agent or the mortgage lender, with the brokers or the parties being ultimately liable for the filing. The Consumer Financial Protection Bureau enforces the Real Estate Settlement Procedures Act, a federal law enacted to protect consumers in the settlement process. RESPA is implemented by rules referred to as Regulation X. RESPA requirements apply when the residential purchase is financed by a federally related mortgage loan. Federally related loans are loans made by banks, savings associations, or other lenders whose deposits are insured by federal agencies. RESPA does not apply to a transaction financed solely by a purchase money mortgage taken back by a seller, installment contracts, or a buyer's assumption of a seller's existing loan. RESPA requires accurate and timely information about the actual costs of a transaction, eliminates kickbacks and other referral fees, and prohibits lenders from requiring excessive escrow account deposits. Tasked with streamlining the disclosure documents and practices under the Dodd-Frank Act, the CFPB began implementing new rules under Truth in Lending Act and RESPA integrated disclosures in late 2015. The rules require that lenders and settlement agents provide the following: special information booklet produced by HUD to every person from whom they receive, or for whom they prepare, a loan application. Loan estimate of settlement costs to the borrower no later than 3 business days after receiving a loan application. The LE replaces the good faith estimate. And initial truth in lending disclosure. Closing disclosure received by the borrower no later than 3 days prior to settlement. The CD itemizes the charges to be paid in connection with closing. The borrower CD replaces and combines the HUD 1 and final truth in lending disclosures. A settlement statement involves an accounting of the amounts paid by or received by the parties, as follows. Debit is a charge that must be paid by the buyer or the seller at settlement. Credit is the amount entered in favor of the buyer or the seller. In most instances, a debit to one party is a credit to the other party. Certain charges are prorated, divided between the buyer and the seller in one of 2 ways. O yearly charge is divided by a 360-day year, or 12 months of 30 days each. O yearly charge is divided by a 365-day year to determine the daily charge. The actual number of days in the proration period is determined, and the number of days is multiplied by the daily charge. In North Carolina, the charges are prorated as of the date of closing, with the seller being responsible for the date of closing. Real estate licensees are responsible for reviewing and verifying accuracy of certain information that may appear on a settlement statement should they be provided with copies of these forms.